Today is the first of 3 lectures dealing with women's human rights. We'll discuss first the key issues and challenges in this area. In particular, we'll identify a distinction between the protection of gender equality on paper in treaties and international declarations and its protection in practice. We'll then explain the distinction between the public sphere and private sphere and how that distinction has been used to critique the understanding of international human rights law prior to the 1990s. We'll analyze the harmful consequences of the public-private distinction for the human rights of women and girls, and we'll end with a discussion of possible responses. Let's begin by first identifying the protection that exists for gender equality or gender non-discrimination in international human rights law. The major international documents dealing with human rights place gender equality front and center. So the UN Charter prohibits sex discrimination. In 1946, the United Nations established a commission on the status of women to address women's rights issues specifically, and numerous global and regional human rights treaties prohibit discrimination on the basis of sex. This would seem to suggest that gender equality is well protected in international human rights law. In fact, however, the human rights system gave insufficient attention to this issue until the 1990s. It gave comparatively limited attention in international venues where human rights issues were promoted, and major human rights NGOs addressed gender discrimination only sporadically. Now, why might this be the case? Well, the critique that was raised was that international human rights law, both explicitly and implicitly, focuses on conduct in the public sphere, and it gives less attention to conduct and potential rights violations in the private sphere. And this distinction between the public and private spheres, the argument went, undermined the human rights concerns of women and girls, or rendered them invisible. In order to understand these concerns, we need to know a bit more about what the public and private spheres actually are. So, what is the public sphere? Well, it applies to public spaces, public actors, such as government officials and others exercising government power, and public issues, meaning in particular the relationship between individuals and these public actors in the public spaces that you see listed on the slide. By contrast, the private sphere involves private physical spaces like the home, the family, places of worship, clans, tribes, etc. Private actors, including members of a family, religious communities, private employers, and private issues, which are interactions between women and girls and these private actors. Once the distinction between the public and private sphere is understood, it may be possible to see how that distinction has harmful effects for women and girls' human rights. And I'd like to recommend to you an article that I will excerpt in the next few slides by 2 leading human rights scholars, Hilary Charlesworth and Christine Chinkin, who in the early 1990s identified this distinction as a key concern and obstacle for the full protection of the human rights of women and girls. According to Professors Charlesworth and Chinkin, the major human rights treaties protected and were inspired by concerns of men, harms that would happen to them in particular in the public sphere in their relationship to governments. And that focus obscured or occluded many of the most pervasive harms that are done to women. And they give a number of concrete specific examples, beginning with the right to life in Article 6 of the ICCPR, the topic that we studied earlier in week 2 of this course. Here you see a key quote from their 1993 journal article, which explains that the right to life is principally concerned with what public actors do in the public sphere, deprivations of life or liberty through state official behavior. And they say that's extremely important, but it doesn't acknowledge the many ways in which being a woman is in itself life-threatening, and the special ways that women and girls need protection in order to be able to enjoy their right to life. Well, this is quite a strong claim, but they back it up with some very persuasive evidence. They explain that from birth, or indeed even before birth, women's lives and the lives of girls are at risk through female infanticide and abortion, through additional suffering, physical and mental, due to malnutrition, due to basic discrimination in gender and healthcare, leading to a disproportionate number of female deaths, and perhaps most importantly, due to pervasive violence against women around the world, in particular violence that occurs within the confines of the family. And they conclude by noting that as a result of the public focus of international human rights law, these types of violations are obscured from view. Now, you might notice here a indirect reference to the negative liberties versus positive obligations discussion that we had with respect to the right to life. Many of these obligations might well be positive obligations on the part of the state to step in and respond in the face of practices by non-state actors or private actors, perhaps even within the family, which violate the human rights of women and girls. Now, what might be a response to the public-private distinction, and how could we use that to improve the protection of gender equality in the international human rights system? Well, one way that this was done, beginning in the early 1990s, was to recognize rape and marital violence against women, as well as violence against women by any family member, as being a human rights violation in new international treaties and non-binding declarations. And indeed, there are such violence-specific, gender violence-specific treaties, I should say, that have been adopted over the last 20 years or so. That's not the only strategy. Another would be to adopt gender-sensitive interpretations and enforcement of existing human rights norms in the treaties and declarations that we already have, that have already been adopted. And that has been done as well. In particular, the focus has been on the Convention on the Elimination of All Forms of Discrimination Against Women, or CEDAW. That's a treaty that we will discuss in depth in the next lecture. For now, I'd like to leave you with a few additional sources if you would like some further information about the issues and challenges facing human rights protection for women and girls.